Hello, I am Dara Graham, nurse consultant with Division of Nursing Homes. I will be conducting this presentation, which provides training for the two new long-term care requirements, F847, Binding Arbitration Agreements, and F848, Arbitrator and Venue Selection and Retention of Agreements. These two requirements have been effective since September 16, 2019. For detailed information about these new requirements, please refer to Appendix PP. In this presentation, I will provide an overview of the requirements, intent, interpretive guidance, investigative protocol, and planner correction for F847 and F848. Starting on September 16, 2019, the requirements for F847 and F848 were added under Administration, Section 483.70. Let us briefly go through the requirements. Under F847, there are 5 key components that the facility must comply with if they choose to offer the resident or his or her representative to enter into an agreement for binding arbitration. The first, the facility cannot require the resident or his or her representative to sign the agreement as a condition of admission or as a requirement to continue receiving care in the facility. The second, the facility must explain the agreement in a form and manner that the resident or his or her representative can understand. Also, the resident or his or her representative acknowledges that they understand the agreement. Third, the agreement must clearly state that the resident or his or her representative has the right to rescind the agreement within 30 days after signing it. Fourth, the agreement must clearly state that the resident or his or her representative is not required to sign the agreement as a condition of admission or as a requirement to continue receiving care in the facility. Lastly, the agreement may not contain any language to prohibit or discourage anyone, including the resident or his or her representative, to communicate with federal, state, or local officials, including state long-term care ombudsmen. Under F848, there are 2 key components. First, the agreement must provide for the selection of a neutral arbitrator agreed upon by the facility and the resident or his or her representative, and the selection of a venue that is convenient to both parties. Second, the facility must retain a copy of the signed agreement for binding arbitration and the arbitrator's final decision for 5 years after the facility and the resident or his or her representative resolved a dispute through arbitration. After reviewing the requirements, let's talk about the intent. It is the resident or his or her representative's right to make informed decisions and choices about important aspects of residents' health, safety, and welfare. The requirements of F847 and F848 are to assure the use of a binding arbitration agreement is voluntary and must be clearly communicated to the residents or their representatives as optional and not required as a condition of admission or to continue receiving care at the facility. For the resident or his or her representative who entered into a binding arbitration agreement, it is important to ensure there is a neutral and fair arbitration process on the selection of a neutral arbitrator, which the resident or his or her representative and the facility agree upon, and the venue is convenient to both parties. Finally, the retention of a copy of the signed agreement for binding arbitration and the arbitrator's final decision enables CMS to fully evaluate quality of care complaints that are addressed in arbitration and assess the overall impact of the agreement related to the safety and quality of care provided in the long-term care facilities. It is important to understand the following legal definitions. Arbitration, a private process where disputing parties agree that one or several individuals can make a decision about the dispute after receiving evidence and hearing arguments. Binding arbitration agreement. A binding arbitration agreement by the parties to submit to arbitration all or certain disputes which have arisen or may arise between them in respect of a defined legal relationship, whether contractual or not. The decision is final, can be enforced by a court, and can only be appealed on very narrow grounds. There are two types of arbitration agreements. Pre-dispute arbitration agreement is to resolve a future unknown dispute with an arbitrator prior to any issue or dispute arising. Post-dispute arbitration agreement is to sign after the circumstances of the dispute having occurred. Convenient venue, a location in which to carry out arbitration proceedings which should be agreed upon and suitable to both parties. It is important to clearly understand the role and function of an arbitrator, as well as neutral arbitrator. Arbitrator, a third party who resolves a dispute between others by arbitration and pursuant to an arbitration agreement. Arbitrators are decision makers with procedures set by the arbitration agreement and state law, except they may not be required to follow federal or state rules of evidence, and their decisions may not be reviewed by a court absent extraordinary circumstances. Neutral arbitrator, an impartial or unbiased third-party decision maker contracted with and agreed to by both parties to resolve their dispute. Over the years, long-term care facilities and residents have used arbitration to resolve many disputes. Parties subject to arbitration give up their right to have some or all claims heard in court. Concerns have arisen about the fairness and transparency related to these agreements. It is important that the arbitration process is transparent. Therefore, the use of a binding arbitration agreement must be voluntary and must be clearly communicated to the residents or their representatives as optional and not a requirement. Whether residents or their representatives choose to enter into an agreement or not, the quality of care received by the resident should not be impacted. In addition, the agreement must be explained so that the resident or his or her representative understands the terms of the agreement and understands that they are giving up their right to litigation in a court proceeding. It is also important that the facility clarify when a signature is used to acknowledge understanding, when it indicates consent to enter into an agreement, or is used for both. During investigation, surveyors must verify through interview and record review that the resident or their representative understood what they were signing. In situations where the resident may have cognitive impairment, surveyors should refer to the medical record to identify the resident's healthcare decision-making capacity at the time the agreement was offered, explained, and entered into. Surveyors should also obtain copies of any documents or agreements that include information about arbitration. For example, if a facility's admission agreement has a paragraph referencing arbitration, but also has a separate arbitration agreement, the survey will need to examine both documents to ensure compliance. In addition to facilities making a reasonable effort to ensure that the arbitration agreement provides for the selection of an arbitrator who is impartial, unbiased, and without the appearance of a conflict of interest, facilities may put forward suggestions for the use of a specific arbitrator for residents or their representatives to select. Where the parties are unable to reach an agreement on a neutral arbitrator, the parties should consult the Federal Arbitration Act 9 U.S.C. Section 5 and or applicable state law. The binding arbitration agreement must allow for the selection of a venue that is suitable in meeting the needs of both the resident or his or her representative and the facility. Convenience for the resident may be determined by his or her needs in terms of ability to get to the venue. The venue must be agreed upon by both parties. When a dispute is resolved through arbitration, facilities are expected to retain copies of the following for 5 years. Specifically, the signed binding arbitration agreements and final decisions. These records must be made available for review to the surveyors upon request. Surveyors should verify with the facility whether arbitration agreements are used to resolve disputes. If so, determine compliance with F-847 and F-848 through interview of sampled residents, resident representatives, resident counsel, family counsel, if one exists, long-term care ombudsman, facility staff, and record review, which includes reviewing the agreement and other relevant documentation. Here are a few examples of what to look for when reviewing resident records under F-847. Review the binding arbitration agreement, any other pertinent information relevant to the selection of the arbitrator and venue, as well as the arbitrator's final decision after resolution of a dispute, if applicable. Here are a few examples of what to look for when reviewing resident records under F-848. Review the binding arbitration agreement, any other pertinent information relevant to the selection of the arbitrator and venue, as well as the arbitrator's final decision after resolution of a dispute, if applicable. After the completion of investigation, surveyors should look for the key elements in order to determine the noncompliance at F-847. After the completion of investigation, surveyors should look for the key elements in order to determine the noncompliance at F-848. Surveyors should always refer to the regulations and guidance to determine they are citing the correct F tag for any identified noncompliance. When determining severity, surveyors may use the reasonable person concept. Severity level 1 does not apply for this regulatory requirement. When citing immediate jeopardy, the surveyor's investigation would have to show that noncompliance resulted in the likelihood for serious psychosocial injury or harm, or caused actual serious psychosocial injury or harm, and required immediate action to prevent further serious psychosocial injury or harm from occurring or reoccurring. Refer to the Psychosocial Severity Outcome Guide. For F-847, based on CMS 2567, surveyors identified systemic noncompliance, indicating a complete disregard or unawareness of the requirements, such as the standard use of arbitration agreements containing language which violates the requirements at F-847, and the facility has made no attempt to explain arbitration agreements to residents. So when reviewing the plan of correction, surveyors must review carefully to ensure the new revised arbitration agreement in use complies with the requirement of F-847, and residents representatives are informed and offered the new agreement that complies with the requirement of F847. For F848, based on CMS 2567, surveyors identified systemic noncompliance with F848, indicating a complete disregard or unawareness of the requirements, such as routinely making no attempt to work with the resident or representative in selecting a neutral arbitrator or convenient venue. When reviewing the plan of correction, surveyors should ensure that all arbitration agreements allow the selection of a neutral arbitrator or convenient venue, as well as define process for 5-year record retention. Thank you for listening. If you have questions, please refer to the arbitration interpretive guidance and/or email the D&H triage mailbox at DNH_triage team@cms.hhs.gov.